Surveillance is on. All right, good evening or late afternoon. I don't know what 4:30 counts as, but today we'll be discussing the state of the Supreme Court's emergency docket in this already not so new second Trump administration. What has changed and how the administration uses the docket, how the court has approached it, and where things may be heading next. To help us think through these questions, we are truly honored to welcome two outstanding scholars and frequent friends of this chapter, Professor Josh Blackman and our very own Professor Steve Vladeck. Professor Blackman is a professor at South Texas College of Law, Houston, where he holds a Centennial Chair of Constitutional Law, and he also serves as the adjunct scholar of the Cato Institute. He is author of 3 books, including an Introduction to Constitutional Law, which many of us have encountered in Professor Burnett's class.
Mandatory reading.
Absolutely. Along with its mandatory excellent companion video series. Professor Blackman has written more than 5 dozen law review articles, cited nearly a thousand times. He is selected by Forbes magazine for his 30 Under 30 in law and policy, is the president of the Harlan Institute, and founded Fantasy SCOTUS, the internet's premier SCOTUS Supreme Court Fantasy League. Professor Blackman received his JD from George Mason University and his BS from Penn State. Professor Steve Vladeck is a professor of law here at Georgetown University Law Center and nationally recognized experts on federal courts, the Supreme Court, national security law, and military justice. He's the author of the New York Times bestselling book, The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic, which has received numerous awards, including the 2024 Order of the Court Book Award. Professor Vladeck is also a highly regarded appellate advocate, having argued before the U.S. Supreme Court and numerous lower federal courts and military courts. He has received wide recognition for his scholarship, teaching, and public engagement, including the University of Texas President's Research Impact Award, selected by the Order of the Coif as Distinguished Visiting Professor for 2025. Professor Vladeck earned his BA summa cum laude from Amherst College and JD from Yale Law School. He clerked for the U.S. Courts of Appeals for the 9th and 11th Circuits. And we are grateful to have him here at Georgetown and joining us today. So without further ado, I'll welcome Professor Blackman to start us off. Thank you so much.
I'll grab to Steve here once again. The emergency docket is not new. The Supreme Court, like all other courts, has an emergency docket. It's had one for a very long time. Sometimes there are urgent cases that require judges to move fast. It can be argued that the modern emergency docket ramped up during the Obama administration. That is the period that Will Bode described in his seminal article, Shadow Docket. Indeed, we just passed an important 10-year anniversary. No, not Justice Scalia's death. It was issuance of a stay in the Clean Power Plan case 10 years ago this month. It was the last case that Justice Scalia voted on and had a momentous effect on the state of energy policy in this country. But the emergency docket didn't really reach its full form until I'd argue in 2017. And I would say the emergency docket is a play that can be told in 3 acts. So Act 1 was the first Trump administration. Biggest issue at the time, travel bans. These orders went through many iterations. Lower courts uniformly blocked the orders, and then Solicitor General Noel Francisco sought emergency relief on several occasions. The court had a bunch of rulings, and they issued some interim orders allowing some policy, but not the entire policy, and ultimately the final version, the most narrow version of the held in a case called Trump against Hawaii. President Trump also attempted to rescind the DACA immigration policy. Lower court ruled against Trump. Once again, the SG sought relief, denied. DACA remains in effect today, except in Texas, where there's an injunction barring its enforcement. There's also the census. In the waning days of the administration, the Solicitor General sought emergency relief to add a citizenship question to the census. That relief was denied. And then the final sort of last gasp was the election after the litigation after the 2020 election. That went nowhere. There were many other cases, but I'll leave it there for now. Right, that was Act 1. Act 2, all the roles were reversed. Now, it was the Biden administration that was adopting its own progressive policies. Conservative litigants filed in red states, and Steve will tell you in specific courthouses, in fact. And these judges, mostly in Texas and the Fifth Circuit, ruled pretty consistently against the Biden administration. Biden, SG listed Lager, had to now seek emergency relief from the court. The record here was mixed. The court blocked the OSHA mandate for all workers for vaccines, but they allowed the mandate to go into effect for healthcare workers. In Biden against Nebraska, the student loan policy was blocked, but mifepristone was allowed to stay on the market. Various challenges to the Biden administration immigration policies were rejected. I don't have time to go through all of them, but you can write a book on it. In fact, Steve did write a book on it. But what's relevant here is that even on a 6-3 conservative court, President Biden won a decent share of cases. It was not all lopsided. All right, we are now in Act 3, which is the most contentious act yet. President Trump's second term has had a different focus. Trump 1.0 was at keeping aliens out of the country, the travel ban. Trump 2.0 is taking aliens in the country out, right? Removing them. So it's a different focus. In the early days of the administration, he invoked the Alien Enemies Act to remove alleged members of Tren de Aragua, a supposed transnational Venezuelan gang. Okay. The Supreme Court largely blocked further removals, but there's still a group of aliens who are stuck in a prison in El Salvador. Judge Boasberg is working on it. Complaints were not turned around as we learned. Trump has tried to use the National Guard to help ICE enforce removal in Minnesota, Illinois, California, Oregon, and other places. The court allowed ICE to conduct searches based on just a suspicion that a person was in the country illegally, all these Kavanaugh stops, if you will. But the court blocked the use of the National Guard to help facilitate immigration enforcement in Minnesota and elsewhere, and Illinois. I thought that Trump might try to issue another executive order in the wake of the ruling in Illinois. He hasn't. I suspect the tragic deaths in Minnesota have put this issue on hold, I think, for some time. So we can put that probably behind us, at least for now. I haven't seen Insurrection Act bandied about, but who knows? State of the Union tonight. Maybe we'll get an Insurrection Act tonight. We'll see. Okay. There have been a rash of cases so far where the court said you filed in the wrong court. These were cases involving terminating civil servants, cutting funding, and things like this. The court says, go to the Court of Federal Claims. There was actually a point in the tariff case that people kind of missed. There were two tracks, one from the DC Circuit, one from the Federal Circuit. And the court said, no, DC Circuit, you lack jurisdiction. The Federal Circuit does. And I almost wonder if there's sort of a general theme that they're trying to funnel things to the right court. Anyway, that was a small part of the tariff case that didn't get much attention. Then there are the firing cases. Trump did it. He fired a member of the FTC. As we sit here right now, Slaughter is still pending before the court. Ruling any minute now, maybe tomorrow, who knows? I think the court likely lets Trump fire Slaughter. Indeed, the court allowed the firing to go forward on the emergency docket. They did not allow the lower court ruling to go into effect. Then there is the situation with Lisa Cook. She is a member of the Federal Reserve. Now, again, Federal Reserve is one that's different. We say the court said that's a different agency. Now, Trump didn't try to fire her at will. He said he's firing her for cause, and the cause to do with a mortgage application. I don't have time to go into it. The court seems somewhat skeptical of it, but they question whether the power to even scrutinize what the president says. I think Trump probably loses this one. In fact, the court's order didn't grant the say. They said, let's just argue it. Okay. There are more emergency docket cases. If you go to SCOTUS blog, they now have an interim order docket blog, which is actually very useful, which lists all the pending cases, how long they've been pending for. Right. So back in 22, he's so prepared. I agree. Back in 22, June of 22, when Steve was still in Texas, we spoke together at the Southern District of Texas in Houston. Remember that? Yeah. It was actually a very good event. It was for law students who were summer interns. And at the time, Steve was working on what became his book. And I don't think I disagree with much of what Steve said, but I made a different one. I said, you know what? I'm with you. Acts 1 and Act 2 are wild, but I think the court's sort of settling down, right? They're sort of coming to a consensus of how to approach emergency docket cases. And I sort of said, let's see what happens the next couple of years. I think for the most part, things are now progressing on a more predictable path than they were in Trump 1.0 and 2.0. I think there's a couple of reasons why. Okay. First, CASA eliminated the nationwide injunction. This was sort of the bugaboo during the first Trump administration. Nationwide injunction. I don't know how much of an effect this has actually had, because virtually any case can be restyled as an APA case, and the courts now issue vacatur under the APA, which in almost all regards resembles a nationwide injunction. Some courts are going through the process of Rule 23 and certification. I don't know how common that is, but we have that, which slows things down a bit and at least addresses the estoppel issues with having multiple parties. Okay. Second, I think the court's been responsive to Steve and others. Steve and others have said, give us an opinion, right? Write something. Show us why. In fact, Justice Barrett used to say, read the opinion. I think the court's doing better. Not where it should be, but they're writing stuff. There are fewer one word, sort of, one sentence. The stay is granted, period, no explanation why. They're at least, I think, trying to explain something. They're trying to cite a precedent or cite a statute or give some modest explanation of why they're doing what they're doing. I'll agree with Steve. It's not enough. I think they could do better. I think the court can write stuff pretty quickly. I think the challenge is getting consensus in short order. I think the Chief Justice could write an opinion before breakfast, right? He do it very well. But the problem is getting at least 5 or 6 other people to agree to that. There's also the issue of concurrences, which is curious, right? Majority opinion is like 1 or 2 sentences long, and then like a justice writes a 15-page concurrence. And Kavanaugh did this in the Fourth Amendment case. Now, I don't think Kavanaugh is speaking for anyone else but Justice Kavanaugh. But it sort of gives the impression, here's what the court's thinking. So look, if the court doesn't want Justice Kavanaugh to speak for them, put it in the per curiam, put it in the main body of the opinion, and I think we'll be better off, right? I'll make this point later, I'll make it now. The justices should hold conferences before they have shadow docket cases. Justice Kagan hinted at a recent case that they couldn't even have a conference, a meeting, before an emergency docket order. This is not uncommon. In death penalty cases, Justice Breyer raised this point almost a decade ago. He said, wait a minute, we're going to execute a guy, allow an execution to go forward, and we can't even meet to discuss. I actually think it's a travesty, right? The court has this calendar that's sort of set in stone that, on certain Fridays of the month, they meet in their beautiful conference room with, John Marshall, actually it's Marbury and Madison on the wall, right? Zoom.
We met in the dining room.
No, which one? Which is the one at the conference? Is it the Marshall on the wall? That one?
No, Marshall's on the conference room. Marbury and Madison are in the dining room.
Dining room. Sorry, confused. That's why he's here.
You with Marbury and Madison, and you reflect on Marshall.
Anyway, so Steve's trying this one. So, there's no reason why the justice can't hold an emergency conference over Zoom. They did it during COVID, right? They couldn't be in person, so they did their conference on Zoom. So I think it would actually go a long way to help to actually write opinions if they hold conferences on Zoom when a case comes up. There's no reason not to. I mean, just circulating opinions is nice, but I think they can actually come to a consensus quicker. All right. The third point I want to make why I think things are sort of settling down is oral argument. And this is something that Justice Kavanaugh has been absolutely adamant about. He's made this point in speeches and his opinions. He wants to argue cases on the short, right? Usually the sequence is, the court grants cert, and then maybe 3 or 4 months later, they have an oral argument. And then, maybe 3 or 4 months after that, you have an opinion. It's a pretty, depending how the summer break goes, entire year could lapse between the start and the finish date. But these are rush cases. I don't think it's ideal, but I think it's better than nothing. The title of Steve's book, I don't like, the shadow docket. I don't use that word anymore. Shadow, right? This darkness, right? These insidious figures in the shadows. Opacity. Sunlight's good. So have an oral argument. And I actually think if they needed to, they can schedule oral argument on short notice, right? We did Zoom arguments during the COVID period. We can do it again, right? I mean, we have a couple of cases pending now that are pretty important. And maybe just have like most of the circuit courts do, a short order oral argument, not the full dress with, that comes in with the marshal and everything else. I think that would actually be more responsive to the moment we're in right now. In fact, I have an idea, and I maybe see that. How many votes do you think it takes to have oral argument on an emergency docket case? Is it 4? Is it 5? What do you think? Or is it anyone wants it? I wondered about this. I don't know the answer.
I don't think there's a number. I think it's a consensus.
So I have a number I'd pick. What number would you pick? How many votes to hold oral argument?
2.
Oh, I do 3. Interesting. Okay, I'm close to you, but we're within the same ballpark. I think if a third of the court wants to hear a case on short notice, and Kagan's made this point, it's like, why can't we argue this case? I think she has a fair point. I would take 3 votes to argue a case. Now, within a reasonable period, it can't drag on forever. And it might be that if you grant the oral argument, maybe you need a temporary administrative stay to last the duration of that period, or shortly thereafter. That might be part of the compromise. All right. 4th, cert before judgment. They've had several of these, and I think what they said is, yes, we know the lower court hasn't ruled, but let's just get on with this. Justice Kavanaugh and others have said, we're in charge. This is CASA, right? We are the top of the apex. We're the top of the pyramid, the apex. So they're saying, we don't really care what the First Circuit has to say on this. That's nice. Let's just go ahead and do it. All right. Number 5, the court has clarified that emergency docket rulings are presidential. I thought this point was settled years ago, but apparently it wasn't. There were some judges in Boston, elsewhere, who said, well, it's just a short order case. It's not precedent, right? It's only governors there. And one judge in Boston said, I didn't even know. Yeah. Now it's clear. The court has actually reversed some judges twice in the same docket for not following its prior decision. Now, I get that judges are frustrated. It's like, how can I possibly know what's a precedent when it's a 1-sentence order, right? I get that. That's why my point number was 1 or 2 is write more stuff. At least that's been settled. 6, I think the Supreme Court is still standing strong. The Costa case I mentioned earlier was remarkable in that the SG said, we will bind ourselves to whatever you say. It was a remarkable concession. That wasn't Marbury. That wasn't Cooper against Aaron. Jack Goldsmith has made this point, right? This was a stunning just surrender of power to the Supreme Court, saying we will follow you. That's not compelled by the Constitution, the Department of Government called the executive. I don't think they had to say that, but they said that. And even Justice Kavanaugh repeated that point in his Learning Resources dissent from a couple of days ago. And I think despite all the craziness and everything that's going on, I think this isn't holding, right? After the Trump press conference was pretty negative, right? Things that were just kind of bonkers, but he didn't say, Mr. Roberts, you made your ruling, go enforce it, right? He didn't say that. He said, I'm going to do these other things that Kavanaugh said I can do. And I don't think those things are actually going to work with Section 112. I don't think it's going to work. But he said it. Okay. I do want to just note that it was really bad that Kavanaugh dragged in their families. That was really bad. Sorry, that Trump dragged in Barrett and Gorsuch's family. That was terrible, especially because Barrett's sister, you may know this, got a bomb threat to her house. And in case you forgot, these people tried to assassinate, a guy tried to assassinate Kavanaugh at his home. I thought that was really bad. And actually, saved the union in 4 hours. I wonder who's going to show up tonight. Maybe. I mean, it's true. I think after the Clinton impeachment, did they all boycott it? Memory serves?
They didn't all boycott the chief one.
The chief one? Yeah. It's my ombudsman right there. So I wouldn't be surprised if a couple of them stay home tonight. But I don't know. All right. Finally, I want to just take a step back and sort of just speak big picture. During the last administration, there's a lot of talk of court reform. And one of the reasons why is this is a right-wing court. It's just partisan institution. And, we can't have our government under this sort of regime for the foreseeable future. Because assuming the actuarial tables work as they're supposed to, there may not be a Democratic majority in the court for a very long time, maybe several decades. Something could happen crazy tonight, tomorrow, whenever, but it might be a while. Look, I would humbly submit that of all the people that Trump could have picked, Barrett, Gorsuch, Kavanaugh, these are not the people that you want to sort of burn the court down or destroy this long-standing institution over. These justices, again, I'm not the biggest fan of all of them, but I think they're truly deciding cases in good faith. And consistently, they decide cases in ways that I don't like, right? Had Trump picked 3 other people, and I can probably name who they are, we would not be having the court we have today. The tariffs would be in effect, right? Many other cases would have come out the other way. Smith would be gone. I mean, I could just go on the list, right? But Trump picked who he picked. So I'll just close this last point. If Alito retires, I don't think he will, or Thomas retired, I don't think he will. Who's Trump going to pick? It may not be someone in the mold of Kavanaugh, Gorsuch, or Barrett. He may have said, okay, I listened to some people the first go around. I'm going to try something different. Thank you for your attention. I welcome Steve's comments.
Okay. A lot there. So let me start with the sort of the what's new part. So I want to fill in, I think, some stuff that Josh may have glossed over. So it's certainly true the Supreme Court has had the power to grant emergency relief, at least in common law, for as long as it's existed, and by statute since 1925. But I think it's really worth underscoring just how radically the court's behavior has changed in the last 10 years and how much that has effected a fundamental shift in what the Supreme Court as an institution does. And it seems like the question we ought to be asking this afternoon and in general is whether this is a healthy shift or not, without regard to the bottom lines of the individual cases. And my suggestion in the time we have today is it is a decidedly unhealthy shift, again, without regard to the bottom lines. So let's first talk about the sort of the shift toward full court rulings on emergency applications. So, Josh pegged this to the late Obama administration. I mean, yes, there's one example from the Obama administration. There aren't others. It's worth, I think, though, stressing what happened before 2016. So between 1925 and 2016, if there was a big question of federal law, we had some of those. If there was an urgent question of federal law, we had some of those too. The Supreme Court would do one of two things. It would allow the circuit justice, acting by themselves, to resolve any application for emergency relief in chambers, often even with an in-chambers opinion, and then that would be the status quo preservation function. Or if it really was sufficiently important, the court would grant cert before judgment so it could give this urgent, massively important question the benefit of plenary review. That didn't happen often. I mean, between 1988 and 2004, I think there were 5 examples of cert before judgment. Between 2004 and 2019, there were 0. And so it was not in any means the norm for the court to intervene early in cases, even in cases in which the Supreme Court would eventually reverse the lower courts, even in cases that had big impacts for statewide or nationwide policies. The only time you saw the full court acting on emergency applications before 2016 was in death penalty cases where the court had moved away from the circuit justice model really around 1980, and we can talk about why in the Q&A if folks want to, and in election cases. And even there, only really on the eve of the election, a la Purcell. What's striking about this shift is that this shift is often pegged to the early Trump administration on the ground that there was just more volume or that it was all about the rise of nationwide injunctions. Really, I think what it was just much more aggressive litigation behavior by the Justice Department. Cases that would not previously have been seen as vehicles for emergency relief that all of a sudden become vehicles for emergency relief. And so that's sort of the first shift, right? The first shift is starting in 2016 with the Clean Power Plan, but really in spades in 2017 is a norm of more full court rulings on emergency applications where the norm is to not write, where the norm is to provide boilerplate and leave it to the lower courts to figure out what, if any, effect the writing has. That started right in 2017. The second shift, and I've got 5 if you're keeping score at home. The second shift is the really dramatic recalibration of irreparable harm. So what is supposed to differentiate emergency relief from the merits? It's not supposed to be the merits, right? Like when you ask for emergency relief, the whole point is supposed to be, hey, not only am I going to win 2 years from now, but if you don't rule for me now, if you don't undo the lower court's ruling, if you don't block this thing or unblock this thing, in those 2 years, I am going to not just be harmed, I'm going to be harmed in a way that cannot be redressed after the fact. That's supposed to be the distinguishing characteristic of emergency relief, because otherwise the Supreme Court is just a court of first impression, which is not supposed to be constitutionally, which it's not supposed to be traditionally, which it's not really well set up to do. Well, starting around 2015, 2016, we see the court gravitate toward this view of irreparable harm, that the federal government is always irreparably harmed whenever any of its policies are blocked by a district court. Now, if you reverse engineer this idea, it dates back to a series of in-chambers opinions by then Justice Rehnquist in the 1970s, where Rehnquist tied this to the presumption of constitutionality, the idea that statutes come to court with a presumption of constitutionality. Okay, that's true, but that presumption, 1, can be overcome, and 2, has not historically applied to executive action. Even more interestingly than that, the court is applying this presumption of irreparable harm even in cases in which the lawsuit is about the president violating a statute. So Josh mentioned the firings cases. You know, whatever you think of Humphrey's executor, whatever you think of the unitary executive theory, you cannot deny as a matter of fact that the president, by removing members of the NLRB or the MSPB without cause, is violating statutes. The point is not that those statutes are entitled to a presumption of constitutionality, it's that the firings aren't. This is one of the moves the court has made that has really changed the calculus, right? If the government is always irreparably harmed, then that means the government walks into court with a heavy thumb on the scale in favor of emergency relief in ways that other parties don't. All right, that would be, I think, a nerdy thing that no one would talk about if it weren't for the next 3. The third move, and this is one that's really become much more visible over the last 13 months, is not just that the court is recalibrating irreparable harm from the government's perspective, it's how the court is balancing the equities. One of the ideas, one of the animating principles of emergency relief is that the courts are supposed to figure out who is harmed worse. So as between leaving the status quo intact or upsetting the status quo, which one will cause more harm in both directions? This is something the court has largely stopped doing, not in general, but only in cases in which the Trump administration is a party. So we have seen the court time and again in the 32 emergency applications the Trump administration has filed since last January, just wash away the equities on the other side. Josh mentioned the ICE raids case out of Los Angeles. He called it the Fourth Amendment case. I might call it the racial profiling case. But what can't be denied about that case is that Justice Kavanaugh's concurrence makes a big deal out of the harm to the government of not potentially being able to arrest up to 2 million Angelenos who might legally have been subject to immigration arrest, and doesn't mention the 10 million people who would be covered by ICE's policy but would not be lawfully subject to immigration arrest and detention. I'm not good at math, but I think 10 million is more than 2 million. At the very least, it seems like you have to explain why those equities aren't equally relevant. The court has stopped doing that. Why does that matter, right? So these two technical moves, the government's always irreparably harmed and the equities, we're not really going to balance them. What that means is that all of these emergency applications just become predictive guesses on the merits, where the court is not doing what it's supposed to be doing on emergency relief, where the court is just issuing a preliminary guess about how it's going to rule on the merits. That's a problem unto itself. It's also a problem because the court is not always good at guessing. We have several fairly high-profile examples in the last few years of the Supreme Court going one way at the emergency application stage and going the other way on the merits. The Supreme Court let Alabama and Louisiana use congressional maps in the 2022 midterms that district courts had blocked. The Supreme Court stayed those injunctions and then affirmed the injunctions, saying, oh, actually, the district courts were right. We shouldn't have let you use the maps, right? The Supreme Court left in place a district court ruling blocking President Biden's immigration enforcement priorities, and then actually threw the case out because it said Texas didn't have standing, right? So this is not how emergency relief is supposed to work. All right, that would all be fine. I mean, not fine, but that would all be problematic enough. Josh says he had always thought that these rulings were precedential. It's funny because Justice Alito said exactly the opposite in September of 2021. In a speech at Notre Dame Law School, Justice Alito went out of his way partly to respond to critics who were worried that the court was acting in a way that was defying its relationship with the other constituent elements of the federal system. Alito says, of course these orders are not precedents. He said, of course. Now, I don't know whether Justice Alito was wrong or not, but that's what he said. Seems like we should be able to rely on what justices say. And yet now the court is saying, actually, right, lower courts are bound to give effect to our assessment of these factors in what the Supreme Court calls, quote, like cases, unquote. What makes case A like case B? We don't know because the court's not writing, right? In fact, in the case where the court says lower courts are bound to follow our prior orders in like cases, the court never actually explained why that case was like the earlier one, when the district court and the Fourth Circuit had both written opinions explaining why they weren't, right? Whatever you think of the results in these cases, that seems like a pretty impoverished way to be deciding these. All right, so that's four. And then there's the last part is it's not just that the court is treating these unexplained orders as precedents. It's that, as Josh suggests, they're criticizing district judges for defying the court's unexplained orders. One really good example is the third country removals case, a case called DVD, where the Supreme Court's original stay had absolutely zero explanation. All it says is that we're staying the April 18th order of the district court. Justice Sotomayor says in her dissent, this other ruling from the district court in the same case is not before us. And then the district court says, oh, well, the Supreme Court only stayed my April 18th order. Sotomayor said the other one's not before us, so I can reaffirm the other order. And the government runs with its hair on fire back to the Supreme Court saying, look, he's defying you. And the Supreme Court agreed. Right? Justice Gorsuch in his concurrence in the NIH case invokes that as an example of defiance. What was the district court supposed to do? The only thing the Supreme Court wrote said we're staying in this order. Justice Sotomayor said not that order. And the district judge is supposed to somehow read the justices' minds to figure out exactly what the meanings of their rulings are. This is why, right, when Justice Gorsuch wrote his concurrence in August, it provoked such backlash from district and circuit judges from across the ideological spectrum. Because, guys, again, without regard to the results, we haven't said anything about the results in these cases, right? The court's behavior is just such a, I think, indefensible institutional shift in how it conceives of its role and how it relates to the lower courts. All right, so let me just sort of briefly respond to a couple of things Josh said, and then maybe we can go back and forth a bit more and have some questions. First, you might have noticed that there was no affirmative case at any point for why the court should be intervening as early and as often as it is. Just because the president asks for emergency relief is not a reason to grant it, right? There are reasons historically why even when we had high-profile litigation, the Supreme Court waited. The justices have said over and over again, we are a court of review, not first view. We benefit from percolation. We don't do well when we're hustling. Why is there some sort of pressure? Why is there some enormous impetus for the court to step into the middle of so many of these cases with no record, right, without any chance to actually let these issues percolate? No one has ever actually made an affirmative case for that. Seems like we ought to be having that affirmative case before we upend our entire system. Second, Josh mentioned the court has, I'm trying to remember what your words were, but sort of done better. Settled down. Yeah. So no. Right. I mean, there have been 31 rulings on emergency applications from the Supreme Court just in Trump-related cases. During the October 2024 term, the court granted emergency relief 31 times in total. That's a record. The court had never done that before. Just to put that number into context, 31 grants of emergency relief. There were 31 total decisions on the merits docket decided through non-unanimous decisions. Right, so the emergency docket is now the same size as the contentious part of the court's merits docket. That is insane historically. I mean, during the entirety of the Bush and Obama administrations, the Justice Department went to the Supreme Court for emergency relief 8 times. That's once every other year. This is not settling down. Josh also called it a more predictable path. No, the only thing that's predictable about these rulings is, as Justice Jackson put it, this administration always wins. Maybe that's the... Yeah, but maybe that's the predictability Josh means. I don't think that's the predictability that would give the court the reputation it should want. And then just to the court reform point, I mean, it seems to me that despite efforts to caricature all court reform proposals as liberals mad at a conservative court, we really ought to be thinking about the court more holistically from an institutional perspective. This is a court that for the better part of 38 years has been completely unbeholden to Congress, has been unchecked by anybody. Justice Alito in the Wall Street Journal in July 2023 says, no provision in the Constitution gives Congress the power to regulate the Supreme Court, period. He's literally incorrect. Article 3, Section 2 specifically does, but it's the zeitgeist, right? The problem with the Supreme Court we have today is not its composition, it's that the court isn't worried about anybody else. The court should be accountable. A court that is accountable would not be able to hand down so many rulings affecting so many people, not explain itself, and then yell at lower courts for not mind reading what they meant. So it seems to me that this is really a symptom of a much broader disease, that the court's behavior has gotten worse, not better, and that whatever you think the court ought to be doing on the merits in these cases, it should be in all of our interests for the court to hand down rulings in which we can all have at least some faith. Not that we agree with the justice's principles, but that we agree that they are at least principled. Thank you.
Steve. Some points of agreement. There are. If we were designing a system on a blank slate, right, no one would design the system we have now, right? If we were to sort of have the Judiciary Act of 2026, start over from scratch, I have a lot of ideas, right? I'm a fan of 3-judge panels. I think those actually might have some salutary effect. I'm a fan of channeling cases on an expedited basis, so you don't have suits filed in 8 different courts on the exact same issue. If we actually had a more regimented process where the Supreme Court had to resolve certain applications by a certain timeline and propose that, I would favor that. But we don't have sort of a blank slate. I also don't think the Supreme Court sort of intended to go in this direction. It wasn't intentional. Sorry, Steve, it just sort of happened, right? It sort of evolved.
Did I say it was intentional?
No, I'm saying this wasn't something the justices dreamt up as a way to give victories to only one president. In fact, I suspected after 2020, they thought Trump would never come back again. And here he is, right? So I think that the system we have now is not ideal. It's problematic. If there is an answer for why we have the system, I think it comes in actually CASA, where this SG said and the court agreed that we are the final say in things. And if we start from that premise, which I actually don't like, I don't believe in judicial supremacy. But we start from the premise that the court is the final say in the law, then what Steve says, predicting the merits, that makes sense, right? If the court's going to say what's going to be, then let them say it now rather than in a year from now, right? If 5 justices is enough, for example, one of the standards is it cert worthy? That was often a standard for granting interim relief. But what's cert worthiness? That means there's 4 votes to grant. There's 5 for the merits. That's as good as cert work. It's even better. So I think what the court's saying is now is we get to decide this law. We are the final say. So the equities and harms don't matter quite as much. I want to just mention one other Obama era case or cases that didn't get enough attention that were emergency docket cases. And these are the same-sex marriage rulings. And people forget about this. So here's what actually happened. Windsor was decided, it was in 2013, right? Windsor was decided in 2013. And if you remember, Justice Scalia had this dissent where he said, nothing stopping gay marriage, right? Gay marriage is coming, right? He had this very sort of blistering dissent. What happened? A bunch of judges started citing, saying, hey, look what Scalia said, right? So the first judge issue was in Utah. And if memory serves, I'll be off the day, he issued a couple days before Christmas. He issued an injunction saying that gay marriage is allowed, and he didn't stay his ruling. And it took several days for the judge even to accept briefing whether to grant the stay. And they raised the 10th Circuit, went up and down, and eventually it got to the Supreme Court like 2 weeks later, right? And then sort of stay was granted, at least temporarily. But by that point, there have been, I don't know how many hundreds of marriage licenses issued. Irreparable harm, you're not yanking back marriage licenses. That's not going to happen in any universe we live in, right? Other courts had similar things where some judges issued rulings where they didn't say the rulings and felt the Supreme Court to intervene. But then finally, at one point, it was actually this very momentous day, the court dismissed all the pending applications for stays. Funny, I think Justice Kennedy had like the wrong court or something. He messed up one of the orders, but they basically just dismissed it. In other words, as a result of this shadow docket, just getting rid of these petitions, lower court injunctions went into effect. That more or less settled the issue until Judge Sutton and the 6th Circuit ruled that the gay marriage laws were valid. I'm sorry, that the bans of gay marriage were valid. At that point, the court had to grant certiorari. But the Supreme Court's decision to allow all these lower court rulings into effect on a seminal question of federal law, is gay marriage required by the Constitution? That was perhaps even more momentous in the Clean Power Plan Award. Right, the denial of that stay there was significant. So I would love to think that, this was sort of just this thing that happened and the court wasn't, really thinking about it. The court gets these issues and decides them case by case. I don't know sort of the path out of this. Maybe some future administration files less emergency injunctions. Maybe Congress sort of starts to regulate how 3-judge panels perform. I don't know. But until Congress actually intervenes, which probably won't happen, I don't sort of see a way out of the shadow docket morass.
All right, 3 quick points. First, on same-sex marriages, the Supreme Court didn't grant emergency relief once in any of the same-sex marriage cases. It was the lower courts that granted stays. The Supreme Court denied applications to vacate those stays as moot on the same day it denied cert. So I think if we're, that was not some like preview of emergency docket stuff. That was the court actually letting those cases go fully through on the merits, denying cert. And it was only once cert was denied and those lower court judgments became final that people anywhere other than Utah were able to get married. But yes, I tell the whole story of the marriage cases in chapter 2 of my book. It turns out the Supreme Court legalized same-sex marriage in more states by denying cert than in Obergefell itself. That's, I think, a pretty useful story of how the shadow docket has always been a big part of the court's work, just not the emergency docket. That was cert denials. To the point, the court is the final say, let them say it now. Well, there are a couple of problems. One is Article 3 of the Constitution, which limits the Supreme Court's original jurisdiction to cases in which a state is a party or cases affecting ambassadors. That is none of these cases. There's a reason why the Constitution has the Supreme Court set up primarily as an appellate tribunal. There's a reason why the relevant statutes Congress has passed, creating appellate jurisdiction, generally have the Supreme Court going last, not first. So that's problem number 1. Problem number 2, the court is not good at going first. They make mistakes. They don't have a record. They make stuff up. A really good example of this is what happened in the EMTALA case a year and a half ago, where the court intervened very early to basically let Idaho continue enforcing its abortion ban, even in cases in which it conflicted with the Federal Emergency Medical Treatment and Labor Act. And then the justices actually had second thoughts and actually came, I think, to regret. Yes, Utah. That was it, right?
That's what I said in Utah.
But they didn't grant relief. You mentioned. Okay, whatever.
So the Sotomayor grant is on January 6th of 2014.
Right, Sotomayor by herself. It was not the full court.
Oh, I'm sorry.
Historically, the court had just, as I said, I think about 10 minutes ago, it was the circuit justices who handled emergency relief, not the full court. That was a meaningful distinction historically.
No, but
This is not a technicality, right? The difference between a single justice issuing an order and
I knew it was a my order. I spoke it precisely. Okay, go on.
I'm not trying to criticize you. I'm trying to say like there's a reason. I'm just trying to say
Finish your points. Finish your points. Okay.
there's a reason why this wasn't the norm until after 2016. To the point about the court having the final say, and so they should be able to say it now. In addition to all the practical reasons, let's just assume you actually are persuaded by Justice Kavanaugh's concurrence in CASA, which I think is an opinion that is very much worth reading. It's what we started with in both my federal courts class and my seminar, which everyone's mad at me about, except for my one student who's in both classes who only had to do the reading once. Right. The problem with so Kavanaugh makes what I think is a version of Josh's case. Like, we're the Supreme Court. We should just take all of these cases now. We should tell you what the rules are and you can go figure it out. So leaving aside all of the problems I just mentioned, there's a larger problem in CASA, which is the court didn't do it, right? If your whole argument for intervening now is to provide a nationally uniform interim answer to the question of whether the things the federal government is doing is legal or not, I might point out that the court didn't actually say a word about the merits of the birthright citizenship executive order in CASA. And so it seems like that theory would fly if you actually owned it. But to say we should absolutely positively go first and then say nothing about the merits there seems kind of inconsistent. As for the path out of this, it actually seems to me that the path out of this is for folks who are less critical of the court than I am, for folks who are more happy with the results the court is reaching in these cases, to nevertheless say publicly that this is not how the court ought to be behaving. It is very easy for folks, I think, especially on the right, to look at people like me and dismiss us and claim that we're bad faith actors and to claim that our procedural critiques are just hiding or covering up for our substantive disagreements. I don't think that's true. I think one could point to a fair mountain of evidence to suggest that that's not true. But I think that if you really believe this is a problem, you ought to say so publicly and not just in Federal Society events. And not just Josh, but other folks. It seems to me that like you can believe that the court is entitled to do this. You can believe that the court is reaching the right answers in many or most of these cases, and still think that we would be better off if the court followed the standards of review, if the court explained what it was doing, if the court didn't chastise lower courts for trying to guess what the court meant. I don't think those things are compatible. Or incompatible. And so if we're talking about a way out, I think one of the things that should be a way out is folks who actually generally like what the court is doing on the merits becoming far more comfortable criticizing the court on procedure. And maybe we can throw it up into questions.
Yeah, so I wrote a paper called Bilateral Judicial Reform, and I have another piece called Unilateral Judicial Reform. I have like a dozen proposals to reform the shadow docket. I can mention in the Q&A, but I don't think we're in a good state. It's not ideal. I think we can find perhaps grounds for improvement. I'll leave it there.
Should we do questions?
Yeah, questions, please, students. Yeah, in the back.
I just wanted to ask that. I mean, with regards to the lack of actual decisions, I think Justice Barrett mentioned at an event I think you were at, just Professor Vladeck. I think what she basically said, and I've seen other people talk about this as the reasoning behind the lack of decisions, is just what you were saying. We don't have a good record. We don't know everything. We don't have, I mean, the learning resources just came down. It took however many months to come up with 7 arguments, and probably half that was just trying to get back at Gorsuch. But it took a while. And they're saying we don't have that kind of time. Well, it was Gorsuch writing, and then they all had to take their more time. But they're just, I mean, this is what sound like Barrett was saying, is we got to get these things out quick. That's the whole point of the emergency docket. And we don't have time to write decisions. Now, I think there's balances there, but what do you think about that argument, both of you? And how do you think that weighs up, that shapes up?
Ivan, you go first to it.
So, I mean, when I've been very public about thinking that the court needs to write, right? I've been equally public that I don't think the writing we're looking for is a 170-page series of opinions. Right? The notion that it's either nothing or 170 pages, I think, is belied by the court's own recent history, where we have seen merits decisions written very quickly. Folks might remember the TikTok case, right, where the court where the court did full briefing, oral argument, and a merits decision in a matter of weeks. Now, you might, think that was a good example. I think it was a bad example. It was an example. So it seems to me that the sort of the 3 principal defenses of not writing. One are it would take too long. If it's important enough, no. Right.
The thing Barrett mentioned, I think, was that once you write something,
then you lock
box
in.
yourself.
Right. So I was saying there are 3. So argument number 1 is it takes too long. I think that's belied by facts. Argument two is we lock ourselves in. I think that is also belied by facts. I mean, I mentioned the Alabama redistricting case, where the only justice who flipped from the majority on the emergency application to the majority on the merits was the one justice who wrote, which is to say Justice Kavanaugh, right? Also, this whole idea that we're going to lock ourselves in, it depends on what you write. Guys, imagine an opinion that says, right, we're really not sure about the merits. It's a close call on the merits, but the equities are so extraordinarily unbalanced that we're going to grant relief, we're going to deny relief, right, without regard to the merits. That doesn't lock them in on anything, right? The problem is that when you are thinking, as Justice Barrett is, that all they're doing at the emergency stage is the merits, you're actually conceding, right, the problem. So I don't think lock-in is a real problem if you write the opinion what to me is the right way. The third argument, and I want to sort of give this airtime because I think it's worth saying it out loud, is that we just can't agree. Right? Like I hear that one a lot. And to which my response is, then why are you intervening? I mean, again, like there ought to be, if we're going to completely transform the role of the Supreme Court in our system, if we're going to completely transform the relationship between the Supreme Court and other actors, it seems like we need a better affirmative case than, well, we would tell you if we actually knew what we wanted to tell you. So I think like those are the arguments that are out there. I'll just say I find them unpersuasive.
So I have an idea. So you mentioned Justice Gorsuch. The tariff opinion again was 170 pages long. Gorsuch was like 50, 60 pages long.
70.
So it was just basically responding to the other four opinions. So my idea is this, I call it the release 6. If 6 justices say the opinion is ready, it's released right away. You don't have time to write a 50-page concurrence. Screw it. Again, this was an important case affecting significant executive power interests. It didn't need to take, was October, it was 6 or 7 months. It didn't need to take that long. So I would almost, one of my ideas is actually put a timeline on releasing opinions, which sort of forces them to come together in sort of the construct of the TikTok case.
I want to ask about the presumption of constitutionality for executive action. As far as I understand it, I mean, your book, you talk about this a lot, but don't you think a respect for a coordinated branch of government, a political branch of government, would compel at least a presumption of constitutionality for executive action, assuming like well-established constitutional rights aren't at stake?
Well, that's it. So I was with you right up until assuming. First of all, the Supreme Court's never said so. And I think that's meaningful, right? I mean, I'm not making this up that the presumption of constitutionality has historically only been about statutes. And indeed, it's about statutes because it is meant to be a derivative of the rational basis test, right? The idea that statutes will generally withstand constitutional challenge if they have a rational basis. We've never said executive orders are subject to rational basis review. Maybe they should be. I mean, I think that's an interesting question. I suspect our answers might differ based upon which executive it is, which suggests that's not really a standard. But also, even if you thought that there are reasons in the abstract to treat the actions of a single person, the president, the same way as a bill that has gone through the gauntlet of both chambers of Congress and a presidential signature or a veto override. And, Rehnquist says that's different. Even if you think those are the same, even the presumption of constitutionality is supposed to give way if there is a colorable constitutional objection to the statute, right? Right, I would think in this case, if the president is allegedly violating the statute. And so it seems like you could maybe justify it as an extension in cases where it's executive action, not in defiance of a statute and not in alleged violation of the Constitution. But if we look at the 32 emergency applications the Trump administration has filed in the last 13 months, that is maybe 5 of them or 6. Right? And that most of the cases are about claims that the president's violating a statute or violating the Constitution or both.
So I think Steve and I agree again. And this was actually one of my ideas in my article. If there's an injunction of a statute that's bicameral presentment, right? Automatic stay. Supreme Court doesn't have to act. Anytime a court, and think of the Planned Parenthood case where there was a spending bill and the judge and boss basically enjoined the spending bill. Anytime there's an injunction of a statute, automatic stay. But in my proposal, there would not be a stay for an executive action that's automatic. You have to go to the courts to seek one. And I think that presumption of constitutionality applies to statutes because of the rational basis test. I would not extend to executive action. Now, again, I wrote this article a couple of years ago before Trump was in office. So my idea, I think, would extend whoever's in the White House. Other question we have? Yeah, go ahead.
Yes, I think this is primarily for Professor Bladdock. So I think this is a question that was raised by Professor Blackman about the broader culture of judicial supremacy and whether that plays into this. So I took Professor Blackman's point about the court coming in and saying we might as well just decide this now because we're the last word on the law, not as an endorsement of that point, but as a like, functionally, this is the culture we live in. And like, it's kind of like unspoken and maybe they don't say directly to themselves, but that's what they kind of believe and have believed since like Cooper versus Aaron, even before that. So I wonder to what extent like that is actually kind of the deeper problem that, as soon as there's a problem in this country, people go to court and they think that it's going to be resolved there because the Supreme Court decides ultimately, and that's kind of the deeper problem here.
So, I mean, I think there are lots of deeper problems here. I mean, just if we think in the longer term about like why so much it seems like our policy fights these days are actually fought in court. That to me is a story about Congress being absent, right? I mean, Josh's proposal to have automatic stays of statutes, if you look at every single emergency application from the federal government going back to 2001, which is for 49, 60, 100 of them exactly, one of them has been about a statute. Right, one of them sought a stay from a district court injunction of a statute as opposed to an executive branch action based on the statute. Right, and that was the Corporate Transparency Act case. I think that's going to always increase the incidence of executive judicial confrontation, and as long as that problem is here, we're going to have real fights over the ability of the courts to be the branch standing up to the executive as opposed to two branches. The question I have, and where I think things are radically under-theorized, is why that automatically gets us to the Supreme Court first, right? Because, on my view, we've had some form of this understanding of the role of the Supreme Court for the better part of 100 years, maybe even a little more. And yet we did just fine for the first 90 of them, with the Supreme Court generally going last, right? That there were a handful of break the glass cases where the court moved heaven and earth to expedite the heck out of the merits, the Nazi saboteurs during World War II, Youngstown, the Watergate tapes case, the Pentagon Papers case, the Iranian hostage crisis case, but that was it. And so one of two things is true. Either all of these cases today are they, and I don't think they are, right? Or the court is intervening in ways that it never did before. And it just seems to me that before the court were to do that, it needs a better account of why. It needs a better explanation for why all of its insistence that it's a court of review, not first view, now doesn't matter, or at least only matters selectively. And it needs some explanation for how it's picking the cases. Because, guys, the biggest problem from my perspective, and I say this as someone who often gets pilloried from the left for being too defensive of the Supreme Court. I'm not looking at you, Robert. Right? The biggest problem from my perspective here, right, is that I'm someone who, like Josh, wants to believe that the justices are always, or at least almost always, acting in good faith, right? Well, everyone has a bad day, right? And the problem, guys, is that when the court doesn't write, it is so much harder to defend its behavior, right? And so, the reason why opinions matter is not just so we can read them in law school. The reasons why opinions matter is to persuade us that there are neutral principles governing what the court is doing. And so I'm willing to be persuaded that there's a neutral principle out there that explains why the court should be intervening so much earlier and so much more often in so many of these cases. The court hasn't articulated it. And the only person who tried, Justice Kavanaugh, didn't even follow it in the case in which he articulated it, right? And so
they only granted cert on the question of the nationwide injunction. They didn't grant the merits case.
That's never stopped them. But I mean, in Dobbs, they decided a question that wasn't part of they did, right?
You would want a Kavanaugh to discuss whether the order was valid in that same order.
Yes, absolutely. I think Kavanaugh's briefed. Yes, it was. I think Kavanaugh's concurrence would have been that much more persuasive if he said, because this is how I feel, I actually would reach out and say now that I think it's likely, because that's the question at the emergency, I think it is likely that the executive order is unlawful, right? And he would have picked up 3 votes easily for that. Interesting question is, would have he picked up a 4th? It's just, what is your theory for we should go first except when we don't want to? That's the part. So again, it's sort of, I have 2 different sets of objections. One is I'm not sure I would be persuaded, but 2, they're not even trying to persuade us. And that's my frustration.
Other question? Maybe someone new hasn't asked a question yet? No, I'll go back. Yeah, right over here.
This is both kind of a really more of a pragmatic question. One of the things that's been touched on is how these collisions between the judicial and executive branch are at least in part driven because of an inactive Congress. And so, to what extent, how do you both react to, well, okay, this is a Supreme Court intervening in a way they haven't done before. But if they didn't, that sort of vacuum of power would further cede a more concentration of authority and power to the executive, which Congress has been happy to see.
So I guess my reaction is actually, just looking at the case from the last year, it's the opposite, which is that what was happening in the lower courts in the vast majority of these cases is it was the lower courts who were blocking the executive. And it was the Supreme Court's interventions in 23 straight cases at one point last year, and 24 of the 28 they've ruled on total, right, from the Trump administration, where the court has cleared the way for the executive branch to keep doing actions that lower courts said were unlawful. And so that's not, listen, you can imagine a scenario where it flipped, right? And where the lower court said go ahead and the Supreme Court says stop. So it's just a quirk of the last year. But I think, again, Congress's absence is why there are more confrontations in the lower courts, right? Does that necessarily mean the Supreme Court should be intervening earlier and without explanation? That's the logical tie I'm not sure I buy.
Right, so I wrote a paper back during the Obama administration called Gridlock, where I sort of explained how the gridlock in Congress, the fact that you're not passing statutes, lead to this clash in the Supreme Court. So there's another Obama era case that might be worth mentioning, which is United States against Texas, one of many such cases. This involved the Docket case. This was where basically Texas went to Brownsville. They started a nationwide injunction to block an immigration policy. Fifth Circuit agreed. It went to the Supreme Court on a very expedited basis, right? Not exactly shadow docket, but on a similar trajectory. And then Justice Scalia passed away, and the court deadlocked 4-4 on it, right? So we have a clear decision. Had Congress passed immigration reform during the Obama year, we would have never had DACA, we've never had DAPA. But these policies became a response to Congress not acting. And then when the executive acts alone, it then goes to the judiciary to decide, in fact, that, how a bill comes to law. Both houses of Congress, the president signs it. So no. It's president signs it, federal judge decides that it's okay, and the Supreme Court agrees, right? That's the new sort of how a bill becomes a law. That's a new trajectory. So the law is made. So, how can we make Congress more effective? I won't mention filibuster, the room will blow up, right? But until Congress starts legislating more, executives will keep doing things on their own. Oh yeah, fine, go to the back.
Right. I very much agree with you. My undergrad thesis was about how Congress is stupid because the people in it are stupid.
I think if there's anything we can find cross-spectrum consensus on in 2026, it's Congress stuff.
Because we follow a bunch of people who want to be on social media. Fine. But besides that, occasionally pass a good law, but Ted Cruz has a good law that's going through the House today, hopefully, requiring airplanes to have better.
The House rejected it.
The House rejected. They finished rejecting it.
The House rejected the no more plane crashes at national law.
I checked back everything I said about Congress being good. Okay. But obviously Congress is hard to reform and change. That's very difficult. It's outside the scope of this. I would suggest to some extent, maybe reinforced by learning resources, that the court is responsible for.
I'm teaching at 5:45.
Yeah,
We'll be on in 2-3 minutes.
Please take 5 minutes.
Let me just put this down. The court is in part responsible for the congressional incapability.
Yep.
I would argue that the CADA combined with severing instead of actually striking down those laws.
Have you read Chaffetz's paper?
Which one?
Josh Chaffetz. So it's professor at Georgetown.
I'm in his class.
Yeah. So
I'll read his paper on that.
Yeah.
So CHADA not severed. CHADA was not even mentioned in the intervening resources, which I thought it would be for sure. I was shocked by that.
Yep.
The fact that we're now going toward a unitary executive theory without non-delegation.
Yep.
I think that the courts also have a part they played in worsening the congressional thing.
I agree. This was I went to the oral argument with Tarek, I was there. CHADA was a big deal. They were talking about it, and Gorsuch for like 100 pages didn't even mention it.
Well, I think
zero citations to it.
Although at the risk of defending Justice Gorsuch, I think his ode to Congress at the end of his 49-page concurrence is all about CHADA without citing CHADA.
Yeah.
Why?
And that's a white opinion. That's his.
Try to deal with that, or
right?
Why not? Meaning in a concurrence, it's a perfect place to say this is something we have to deal with.
So let me just say two things. The first is I completely agree with everything he said. Chavez had his paper is called The CHADA Presidency, and it's actually, I think, like deeply in line with what you're saying. I guess the thing I would say is, yes, the court can and should be doing a lot more to prompt Congress to action and to not sort of clean up Congress's messes for it. But the place to do that, and I think maybe you were getting there, the place that's the merits docket, not the emergency docket, right? And part of the problem that's happening is in the emergency docket, the court is actually allowing the president to run roughshod over congressional actions in ways that are disincentivizing Congress. And one example, and I'll shut up, right? The shutdown last year, right? Right before the shutdown, the court granted emergency relief in a case called AIDS Vaccine Advisory Coalition, where the effect of the grant of emergency relief, which was not explained, well, it had like 3 sentences of explanation, was to allow the president to basically pocket rescind, $4 billion in foreign aid funding. If you're a Democrat in the House and you're negotiating a shutdown deal, right? What is your incentive to actually agree to a deal that the Supreme Court has just said the president doesn't have to follow? Right, and so like I agree with you entirely that the Supreme Court bears responsibility for this. I just think that the emergency docket has actually made it worse, not better.
Thank you, Dave. We can run our.
Yeah,